Good afternoon, and thank you for joining us for this speed briefing about a new practical toolkit on international protection for people displaced across borders in the context of climate change and disasters. My name is Jane McAdam, and I'm the Director of the Evacuations Research Hub at UNSW's Kaldor Centre for International Refugee Law. I would like to acknowledge the traditional owners of the lands on which we are all meeting today, and I pay my respects to elders past and present, as well as to Aboriginal and Torres Strait Islander colleagues joining today. I will begin today's event by providing a short overview of the practical toolkit. As I do this, you're most welcome to type any questions that you have via the Q&A button on your screen. We will then come to the questions for around 15 minutes after the briefing. For a long time, it seemed that refugee law had little relevance to people fleeing the impacts of climate change and disasters. Nearly 30 years ago, the High Court of Australia remarked that people fleeing a natural disaster or natural catastrophes could not be refugees. The Supreme Court of Canada said that victims of natural disasters, as they put it, could not be refugees, and I quote, even when their home country is unable to provide assistance, and even if the case might seem deserving of international sanctuary. But we've learnt a lot in the intervening years. Above all, we've come to understand how the impacts of climate change and disasters interact with other social, economic, and political drivers of displacement. In other words, climate change and disasters are part of the hazardscape that creates risks for people. This means that even though there's no such thing in law as a climate refugee, there are most certainly people who are placed at heightened risk because the impacts of climate change or disasters generate or exacerbate a well-founded fear of persecution or other serious harm. Now, those impacts can affect different people in different ways. Factors such as age, gender, disability, or health may intersect to create particular risks for particular individuals or communities. Displacement in the context of climate change and disasters is not just a future phenomenon, it's happening now. And while most people displaced in this context are likely to remain within their country's own borders, at least initially, some people will move across international borders in search of safety and protection. This means that increasingly, legal practitioners and decision makers are grappling with whether and how the impacts of climate change and disasters may substantiate or support an international protection claim. Over the course of the last decade, an important body of case law and guidance has been developed that clearly shows how, in the right factual scenario, some people could indeed qualify for protection as refugees or as beneficiaries of complementary protection under human rights law. As these cases show, there is no need to reinvent the wheel, to create new principles, or to make things overly complicated. The better option is to apply existing international protection principles to the facts at hand, appreciating how the impacts of climate change and disasters interact with the broader social and political context and how they intersect with other drivers of displacement. This is why we developed the Practical Toolkit on International Protection for People Displaced Across Borders in the context of climate change and disasters. And by we, I mean the Kaldor Centre, together with the Centre for Gender and Refugee Studies in the United States, as well as Essex Law School and Human Rights Centre in the United Kingdom. And this was done with the generous support of and interaction with UNHCR. In the course of preparing the toolkit, we consulted widely with a broad range of decision makers, legal practitioners, UNHCR protection officials, and legal experts across the world. And we thank all of them for their interest and engagement in that process. At the Kaldor Centre, we would also like to acknowledge the Open Society Foundation's generous financial support for this project. So, the Practical Toolkit provides a clear, detailed, and action-oriented resource for legal practitioners and decision makers who are tasked with assessing or developing international protection claims where the impacts of climate change and disasters are raised. The Practical Toolkit is accompanied by a shorter overview document setting out the key considerations that should be taken into account in any such claim. And these are as follows. The first one is that there are no special rules for international protection claims involving climate change and disasters. In other words, it's a business as usual approach, and we explain why and how that's the case. Secondly, the hazardscape should be considered as a whole. Thirdly, climate change and disasters affect people in different ways. Fourthly, human agency contributes to the impacts of climate change and disasters. And finally, the risk of harm may manifest over time. These 5 overarching issues respond to common misperceptions or oversimplifications regarding the connections between climate change, disasters, and displacement, and the role of international protection. I'll speak about them a little more in a moment. The toolkit focuses on international refugee law and human rights law frameworks, and also on their regional counterparts in Africa, the Americas, and Europe. It explains when, why, and how existing law can apply to claims where climate change or disasters play a role. It shows why international protection claims arising in this context should be assessed just like other protection claims, namely, through a systematic application of the applicable legal criteria to the facts of the individual claim. So what we are not trying to do here is extend the scope of international protection, but rather explain how climate change and disasters can contribute to establishing the factual basis for international protection under existing international and regional frameworks. And that's really the purpose of key consideration 1. The Practical Toolkit emphasises the importance of assessing the impacts of climate change and disasters within a broader social context, including underlying systemic issues of discrimination or inequity that may impact on how people or particular people experience harm. A cumulative assessment of risk is particularly important, since risks may emerge over time rather than as the result of one extreme event. The toolkit emphasises the importance of looking at the hazardscape as a whole in identifying and assessing that future risk of harm. And that's what key considerations 2 and 3 are about. Key consideration 4 concerns the role of human agency, which is generally required in any international protection claim. Importantly, this doesn't mean that we need to show or establish human agency with respect to a particular hazard or disaster, or for climate change per se. Rather, human agency must be a factor in creating the risk of serious harm to the applicant, or in a government's failure to protect somebody from such harm. Finally, as in all international protection claims, it's important to make a forward-looking assessment of the risk of harm. While the assessment of future risk must be made at the time the claim is determined, there's no limit on the future timeframe in which the risk is assessed. So, assessing the risk of harm over time is crucial, even for apparently one-off disasters, because their impacts may be felt over a much longer time period. And that is the focus of key consideration 5. In conclusion, we hope that the Practical Toolkit serves as a useful, practical roadmap for legal practitioners and decision makers who are considering protection claims involving climate change and disasters. We also hope that it will provide the basis for the development of national level guidelines in other countries, such as existing guidance in the United States developed by our colleagues at the Centre for Gender and Refugee Studies in 2023. The Kaldor Centre will be drafting national guidance for Australia over the course of this year, and we look forward to sharing it with you in due course. I'm now delighted to invite Madeline Garlick, the Chief of UNHCR's Protection Policy and Legal Advice section in the Division of International Protection in Geneva, to join us. Madeline is going to offer some brief remarks about UNHCR's engagement and support of this engagement in and support of this work, for which we're truly grateful. And then Madeline will invite my colleague, Tamara Wood, who is one of the co-authors of the Practical Toolkit, to join us so that she and I together can answer your questions. Over to you, Madeline.
Very much, Jane. And let me simply say to start with how much UNHCR appreciates the work of all concerned on this tool. We're very proud and honoured to be associated with the process, and I really want, on behalf of the organisation, to pay tribute to all involved, including notably the authors, for their hard work and commitment to producing this important toolkit at this timely moment. In the course of UNHCR's work around the world, we are increasingly seeing on a day-to-day basis how the adverse effects of climate change are affecting countries in regions from which so many of the world's refugees originate. We can testify, as Jane has underscored, that displacement in the context of climate change and disasters is not just a future phenomenon, it's happening now. We also observe that people affected by the impacts of climate change and disasters, including those which interact with persecution, violence, and other drivers of displacement, are seeking protection in other countries in different regions of the world, including notably some of those that are most impacted themselves as receiving countries by climate impacts, including in the Sahel, in parts of Asia, and in other parts on the African continent. Since UNHCR produced its 2020 legal considerations on asylum claims made from people displaced in the context of climate change and disaster, we've seen increasing recognition of the potential relevance of international refugee law, as well as human rights law and other legal frameworks that are applicable to the claims of people displaced in such settings. But we also see many questions which are preoccupying decision makers, judges, lawyers, and other practitioners around the world around precisely how these frameworks should be applied in practice in dealing with such protection claims. And so it's against this background that a toolkit such as this has the potential to play an enormously important role in helping all of those working in this sphere to be able to contextualize the relevant legal principles and provisions, and to present them in ways that can help ensure that people who do fall within the refugee definition or otherwise are in need of international protection can be correctly identified and can be given the protection that they need. We hope this will also, in turn, help those who are conducting research, who are also analysing these phenomena, also those who are in dialogue with governments, with judges, with courts and others, as well as legislatures, which in many parts of the world are also looking at ways in which they can address the increasing challenges around displacement and protection needs arising in this context. We're particularly appreciative also of the way in which this toolkit has looked at very practical considerations, highlighting some of the key and developing trends in jurisprudence, which are also going to be of particular assistance to decision makers. And we hope that this is going to help also ensure that there can be a productive dialogue on this in the many fora in which these challenges are increasingly being discussed. We see a need for more discussion about what this means for particular countries, for particular populations that are on the move, and for those who are dealing with these claims in the very complex contexts in which they arise. So with that, we really appreciate the opportunity to be part of this launch. We hope that the discussion that is going to take place, including between Jane and Tamara around their perspectives, is going to contribute also to further thinking in this area and to lead to more discussions, which are going to help advance the thinking of all of us working in this field. So with that, thank you very much, Jane. And I believe now is an opportunity for us to hear from Tamara on some of her perspectives on the important topics that are addressed in the toolkit. Tamara, over to you.
Thank you, Madeline, and thank you, Jane. It's a real pleasure to be able to share the toolkit with everyone who's joined us today. And we really invite you to take this opportunity to ask us your questions. So you can post those into the Q&A box on the screen, and we will do our best to answer as many as we can in the short time that we have. While you're doing that, perhaps I'll just share a couple more reflections on what I think is quite unique about the toolkit, and some of the ways that we hope that it will really benefit practitioners, decision makers and others who are working on this issue, not just in theory, but at the coalface. As well as the key considerations that Jane very clearly laid out, there's a couple of other quite unique aspects to the toolkit. The first is the combination of the very principled international law analysis with how these issues are being dealt with already within national jurisdictions. There are national jurisdictions including New Zealand, Italy, and others who have already begun to develop a really useful body of case law, applying established international law principles to specific case scenarios. I think the toolkit is also quite unique in the level of detail, or the level of detailed analysis that it provides, not only of international frameworks, but also regional frameworks, including in Europe, Africa, and the Americas. And finally, the toolkit includes some suggested fact-finding questions, the kinds of questions that will help legal practitioners and decision makers to look behind the manifestation of climate change and disaster impacts, to look at underlying social causes, discrimination, vulnerability, and so on, to really probe into potential grounds for an international protection claim. I'll hand, I think, now to Madeline, who might take us through some questions, but I thought perhaps I could begin with one myself and throw to Jane or Madeline. Which are the countries that are already starting to build the jurisprudence, and from which the case law in the toolkit is drawn? Jane, perhaps we'll start with you.
Thanks, Tamara. Yeah, so New Zealand has really been the jurisdiction that has led the way here. Typically, or originally, with claims coming from the Pacific, from Tuvalu, from Kiribati, but also claims from elsewhere. And there was a particularly interesting recent decision involving an elderly couple from Eritrea who were found to have a need for protection on the basis that they were at serious risk of inhuman or degrading treatment if removed. And it wasn't as though climate change was the only reason why that claim was made out, but it certainly was an important factor. And that was in part because as elderly people, it was found that they would face particular vulnerabilities to things like impoverishment, resource scarcity, ill treatment, and so on, that were amplified by the impacts of climate change. So it was a good example of how a particular characteristic that was held was seen to heighten vulnerability or heighten that risk in the climate context. Probably the most famous case from New Zealand is that of Mr. Tessiota, which went up to the UN Human Rights Committee. And although there was, in the end, he was found on the facts not to have an international protection need, it was a very important affirmation of the principle of non-refoulement, or the principle of non-removal, specifically in the context of climate change and disasters. And in that case, that was in relation to a real risk to his life. But it was also stated that, if the facts were such, there's no reason why a person couldn't also, at the New Zealand level, it was noted that if the facts, fell into the right sort of matrix, a person could also potentially be a refugee on that basis. And I'll turn to Madeline in a second, other than to note Italy too has been producing some very interesting case law here. There are cases from other countries, but it's in our own region really that the groundwork was laid. Madeline, did you want to comment?
Yes, thank you, Jane, and thanks, Tamara. Indeed, as you mentioned, Jane, there have been some interesting decisions in Italy, including from some of the regional tribunals, which amongst other things have found that asylum seekers who are at risk of trafficking upon return have been given international protection because of the circumstances in which they've been they have been displaced, which have taken these principles into an interesting and new context. We've also had some decisions in France that have recognised that pollution and environmental degradation in Southeast Asia have also led to risks which necessitate the grants of international protection. But as you've said, Jane, it's really in the Asia-Pacific region where we've seen New Zealand leading the way on decision-making in these cases. So I think it's really important for us now with this global tool to be offering the opportunity also for decision makers in other jurisdictions to reflect on what this means and what are the potential applications of international protection principles for some of the claims that they may be receiving. As Tamara mentioned, also the regional scope of this toolkit also means it has important potential, I think, for decision makers in the African continent to also draw on this. We see a great deal of interest amongst African judges, including members of the Africa chapter of the International Association of Refugee and Migration Judges in this topic. That was a discussion at last year's regional chapter meeting, in fact. So we hope that there's also going to be further reflection and potential use of the toolkit and some of the principles articulated therein for decision making in Africa, because that's one continent where we really do see, as UNHCR, very significant movements across borders in the context of climate change and disasters, often also combined with the effects of conflict and violence, including, amongst other things, in the current conflict in Sudan. And so we see that there is significant potential for these principles to be applied on a much more global basis in the future. Perhaps I should just take the opportunity also to invite our participants, of which we have a number online, to put any questions that they may have in the chat. We've got a great opportunity here in the time we have today to have an interactive dialogue. So it's really a wonderful chance, if anybody is wishing to do so, to put their questions into the Q&A, and either myself or Tamara or Jane or Tristan would be ready potentially to take those on.
Perhaps I can.
As we have nothing
sorry,
outstanding at this stage, Jane, do we want to come back to you?
I realised too that it might be helpful for the audience to explain how it was we kind of felt there was a need to develop the toolkit, because on the one hand, it might seem obvious that refugee law and human rights law should apply. And yet for a long time, kind of going back 15 or so years, I think there was a feeling among some that, well, maybe we just need to create this whole new instrument. We need to change the refugee definition, or we need to add a protocol. And I think what's been very evident is there's no political will to do something like that. But equally, I think we, as I sort of explained in my introduction, we hadn't yet properly understood how climate change and disasters could factor into, the sorts of claims we were seeing and how they, how they affected people. So even though there was, I and others were saying, well, refugee law might apply, but only in very confined circumstances. And we're certainly not saying it is the only answer. I think it is important to explain to those who are faced with claims, or whether they're decision makers or lawyers assisting people, the sorts of considerations that they should be thinking about. And I think in informal conversations, with decision makers and others, I think sometimes people are a little bit spooked that they don't feel they have a very good scientific knowledge about climate change. And really, this is to reassure those people that that's not what this is about. Just as decision makers already have to look at the country conditions as a whole, they look at reports from governments, from reputable human rights organisations, from UNHCR and others. It's really about applying that same technique, but now instead of maybe looking at a conflict, or as well as looking at a conflict, you're looking at disasters and climate as well. So in that sense, it's really to not just reassure decision makers, but provide that very practical guidance as to, what do you actually do step by step. And at the end of the practical toolkit, we include some questions that you might use to sort of elicit that or understand that kind of information, and extra resources that people can go to if they want more in-depth analysis of particular areas or concepts. Oh, Madeline, you're on mute.
Thank you, Jane. No, I think that's really important what you've highlighted. And indeed, as you say, in the past, I think there has been a perception that existing law doesn't address this phenomenon, and that we, particularly amongst academic and some human rights actors, we've seen discussions of the need for a new instrument. But what UNHCR and yourself, the Kaldor Centre, and many others have been arguing for some time is indeed existing law can be and is all directly relevant. And so that's what I think the toolkit is potentially going to help decision makers precisely to do more effectively, is to take the principles of refugee and human rights law, which after all have been interpreted in an evolving way for many years to address many contemporary forms of persecution and human rights risks in a wide range of settings over time, and help us to apply those to today's movements that are taking place in the context of climate change and disaster. Now, we have some of our participants, I see, who've put some questions in the chat. And we have one here from Jasmine, who is asking if we've had applications of these principles before tribunals and courts in Australia. And I'm wondering, perhaps, Jane, if you would want to say a couple of words to that. There's then a question from a participant who asks about the Global Compact on Refugees, and I'd be happy to say a few words about that one. And then thereafter, a question about the assessment of future harm. So I don't know, perhaps Jane and maybe Tamara, you want to say a few words about those, and I'll come back on the Global Compact.
Sure. Well, perhaps on the latter, I've actually just sent a link through to our host to see if they could perhaps post an article that I wrote with colleagues a number of years ago, really looking at how far into the future can we assess harm, because unfortunately an erroneous notion of imminence has crept into some decision making, and we explain why that is an incorrect approach. And there have been some interesting cases involving children and fear of harm occurring into the future, and how far have courts and tribunals looked. So that's one thing you could take a look at. In terms of Australia, there have been cases, although nothing that mainly in the tribunal. Certainly in the 90s, 2000s, there were some, and there was a piece I wrote several years ago in the journal Migration Studies, which analysed those. In more recent years, there hasn't really been anything of particular significance. And of course, one thing that we do mention in the toolkit is that in applying these principles, of course, different countries will have different domestic legislation. So obviously that needs to be considered. New Zealand directly refers to the international conventions in its law, which kind of opens up that possibility to have almost that direct line of authority that goes right up to the UN Human Rights Committee. Australia implements those obligations somewhat differently. But I think that the broad principle still stands, that with the right factual matrix, Australian law would need to respond in a similar way to the way New Zealand courts have done. Tamara, did you want to add anything there?
Sure, thanks, Jane. Just on the question about future harm, I might mention a New Zealand case that involved an applicant from Kiribati. This is one that's discussed in the toolkit, where the consideration of future harm had to take into account not only the sort of progression of climate change and the impacts that it's likely to have in the future within the country, but also the likely actions by the government and whether that could reduce the risk over time. And ultimately, the tribunal in that case found that because of the very devoted attention by the Kiribati government to mitigating impacts of climate change and to facilitating adaptation and so on, that over time that was likely to actually reduce the risk. And on the Australian courts and tribunals, again, we've had quite a lot of consultation and conversations with decision makers in Australia. And my sense is that often cases that involve climate change and disasters are being decided, but they can sort of be decided based on other factors. But decision makers are acutely aware that the impacts of climate change and disasters, as they are increasing, may come to the fore more and more. So we anticipate this might be something that we see more in the future, and also more as claimants come to understand that this could be relevant to their claim. I think at the moment there's probably quite a reticence amongst people seeking refugee status to invoke climate change and disasters for fear that it might actually negatively affect their claim because of some of those misapprehensions that have informed the case law. Over to you, Madeline. And I realise we're running out of time, but would be grateful for your thoughts on the Global Compact question.
Thank you very much. Yes, by all means. You've got in the chat there a short document that UNHCR produced in 2018, which analyses the specific passages in the Global Compact on refugees that are relevant in this context. And indeed, it's important to note that the Compact does underscore that, and I quote from para 12, external forced displacement may result from sudden onset natural disasters and environmental degradation. And it highlights that states may be seeking support from the international community to address the complex challenges that arise from such situations. And I think this is a really important opening that signals that the General Assembly acknowledges that there is a direct link between international protection needs and the phenomenon of displacement in climate impacted contexts. And that document outlines some of the other important aspects that are also addressed in the Global Compact around prevention and displacement and addressing root causes, protection and assistance, including the roles of various stakeholders in this connection, as well as the potential for follow-up. And that follow-up has been also very manifest in the Global Compact, the Global Refugee Forum, where we had last year, in 2023, a significant number of participants in the multi-stakeholder pledge on climate change, which has underscored again the importance and the interest on the part of many stakeholders of taking action to address this in different ways. So we see that there, in the same way that the Global Compact is seeking to provide a framework for practical implementation of binding refugee law, it is really providing an opportunity for us to take this forward in the climate setting as well. As you say, Tamara, we're running out of time, but I wonder if our participants want to also just say a word on another interesting question that has been raised here about the relevance of the toolkit to internal displacement situations. Jane, did you want to
Yeah, I mean, just briefly,
this?
Thank you. The toolkit very much has as its focus cross-border movement and the analysis of refugee law by its very nature applies to such movement. I suspect you could look at how harm might, or real risk of harm, the sorts of things we discuss in the context of inhuman or degrading treatment potentially could be applied in an internal setting if one is trying to understand, well, what would amount to that kind of ill treatment, but that's certainly not the intention of this particular document. And of course, most displacement in the context of climate change and disasters is internal. So in that sense, it requires, a holistic response primarily by the national government, but also with international collaboration. And the guiding principles on internal displacement are instructive there.
Thank you, Jane. No, I think that's a critical point, that indeed this question of protection of internally displaced people is also, of course, a very current one in many discussions in this context. And it's one that I think as people who are working in the field of human mobility in this connection need to continue to discuss and to explore further. Everybody, I think this has been a great start to the process of using and putting into practice the toolkit and the important support and assistance that it seeks to provide to those working in this field. We hope that there'll be other opportunities to discuss this further, and let me again just really pay tribute to all of those involved in producing it so far. UNHCR, the Kaldor Centre, and all of the academic institutions that were involved in its production, I know are going to be continuing this work and looks forward to hearing from users of the toolkit also of their experiences so that we can continue to build on this and to increase awareness, understanding and use of these principles in practice to address the many challenges that we see in this field. So thanks very much, everybody, and wishing everybody a good afternoon, evening and day to come. Thank you so much.